Well, we had the Karen Reed hearing today on Double Jeopardy. And if you've been following this channel and you've been listening to how all of the case law in Massachusetts plays out and what the law is in Massachusetts with respect to Double Jeopardy, you were probably disappointed. And I don't blame you, because I was also a little bit disappointed by the way that the oral arguments went. And let's just take a moment and we'll break down what the arguments were and why I think it could have been done a lot differently. Certainly, if I was the one arguing whether it's on the side of the defense or whether it's on the prosecution, I would have taken different approaches with this specific argument. So what did the defense argue? The defense spent a lot of time, and I mean a lot of time, on the notion of what double jeopardy means and how it's so categorically unfair to have a person be tried on a crime twice. And we can all agree, I think the judge agrees with this also, that it's terrible. If double jeopardy does apply in this situation, then of course we have to follow double jeopardy laws and not allow Karen Reed to be charged again. So the fact that we spent so much time on that double jeopardy is just terrible, sounds like much more of an emotional plea to please, let's just bring the jury back and make sure that we're not trying somebody for the same crime again. And it spent a lot of time on that. But emotional pleas don't really work in court. And yes, they're heartfelt, and maybe we feel bad for the person. But if you want to win your motion in court, you've got to have citations to law, to authority, to statutes, to rules. And then you can argue that in this specific situation, double jeopardy should attach. And there was a lot of time spent on the ambiguity of the note that said we're hung on the charges, or we can't come to an unanimous decision on the charges. Did the charges mean that it was all of the charges, or did it just mean the charges in count 2? We've spoken about that. There was a lot of talk about that. There was a lot of talk about that form and procedures shouldn't be what guides us in something as important as double jeopardy. It should be more substance. And since here, the substance of what the jurors are saying now is that this is totally a situation of double jeopardy, so we should not allow Karen Reed to be tried again on count 1 and count 3. And there is some case law that says that we prefer to decide issues based on substance much more than form and procedures, right? Rules and procedures are nice, and forms and the way that you're supposed to do things, you're right, that's important. But if the substance of something is screaming at you for one outcome, and the form and procedures are saying, well, you forgot to click this box on the form, so I'm sorry, we just can't grant that to you, then of course there's a million cases that all stand for the same proposition that, yeah, of course, the courts should favor substance over form and procedure. So this was also a long-winded argument about how this court should not favor form and procedure over substance. And the idea here is that, well, you know, the form here, the correct form, the correct procedure is that after the jury is done with the deliberations, they come out to the court with their verdict. But here, the form should just be a little bit different, that there's a few-week break, but let's bring them back now and let's voir dire them and see really what their verdict was, 2 months ago or 3 months ago. And therefore, that's what one of the arguments were, that we should favor substance over form and procedure. But again, it all comes down to the fact that what case or what cases are similar to this situation that happened in Karen Reed, where the judge allowed the jury to come back and give another vote. And the only cases that show us anything like that is when there's racial and ethnic bias, or if there's coercion from an outside source, jury tampering. If there's something like that, then we've seen cases that allow the jury to come back, get voir dired. Everybody agrees with those. The question is, what about this situation? There's no arguments that any of the jurors were coerced, or that there was jury tampering, or that there was any racial or ethnic bias that was injected into the jury deliberations. There's no argument for that. So what argument is there to bring the jury back? What authority tells us that we can do that? And the only argument that I heard today was the fact that, well, it's so important. Double jeopardy is just so important to not allow a defendant to be tried twice for the same case, because that's so important. That's why we should bring the jury back. And the problem is that double jeopardy has been around for a long time, and there's been a lot of cases, probably with similar situations, and we didn't find any cases that stand for the proposition that you can bring the jury back. So if the only cases you find are when there's racial or ethnic bias, or when there is jury tampering, and that's the only time that we allow the jury to come back, then the judge is not just doesn't have any authority to hang her hat on to bring the jury back. So like I've said from the beginning, that part of the argument is the weakest part. And for some reason, that's where most of the attention was. And in fact, that's essentially what he asked for. He asked, all we're asking for, Your Honor, is to bring the jury back into a very simple voir dire. What was your verdict on charge 1 and charge 3? That essentially was what he was asking for. Okay, so now if it was me, if I was the one arguing this motion, I wouldn't be asking the judge, you know what we're asking for, Your Honor? Really, all we're asking for is to bring the jury back. That would not be my argument. My argument would be the following. Your Honor, maybe I'd spend a few minutes on the jury part just because it's to complete it, but I didn't think that that's going to win the case. And you say, Your Honor, what this case is really about is whether Your Honor's declaration of a mistrial was appropriate. And I don't mean any offense to Your Honor, but it seems from the case law that in this specific situation, in these circumstances, the declaration of a mistrial was improper. And the reason for that, Your Honor, is for a few different reasons. Number one is that when you got that note, you just immediately declared a mistrial without having any input from counsel. You didn't ask us before when you received the note if we have any input or what we want you to do. You just brought us into court with the jury present. You read the note and then you immediately declared a mistrial without us having any opportunity to object, because we would have objected. We would have said, Your Honor, we don't agree that a mistrial should be declared. We want to ask them on charges 1 and charges 2 and charges 3 and see if they reached a verdict on any of them. That's what we would have done, but we just weren't given the opportunity, Your Honor. And also, that's as it relates to the fact that we certainly did not consent to this mistrial, but also the fact that a mistrial can only be declared if there's manifest necessity, either a request or there was consent, or if there's manifest necessity. Well, I've already established to Your Honor that there was no request. That's simple. There was no consent because you didn't give us an opportunity to object. And number 3, there's no manifest necessity, because in order to rely on manifest necessity, you have to have given full opportunity to be heard, Your Honor. And number 2 is that you also have to give careful considerations to any alternatives to declaring a mistrial. And if you would have asked us, we would have told you that you should ask about charges 1, 2, and 3 separately and see if they reached a verdict on those charges. And because those two requirements in order to find manifest necessity were not met, because Your Honor did not do them, so that's why the declaration of a mistrial was inappropriate. That's why double jeopardy attaches in this case, Your Honor. We don't have to bring the jury back. We can leave them all, let them enjoy their private lives as it is now. And really, just, Your Honor, the declaration of mistrial was just inappropriate, and therefore that's why double jeopardy attaches. That would have been a much stronger argument. And then you can also cite some case law. You got some cases like Stewart, Commonwealth versus Stewart, says specifically, in a situation where the judge didn't give careful consideration to alternatives to a mistrial, that case specifically says that the mistrial was inappropriate and therefore double jeopardy attaches. So, Your Honor, it's straight out in Commonwealth versus Stewart. And there's some other cases that I've cited in my previous videos that also stand for the same proposition. When defense counsel is not giving the full opportunity to be heard and there's no careful consideration of alternatives, so then the declaration of a mistrial was inappropriate. That is the argument that you make if you're the defense attorney. Now, if you're the prosecutor, what you get up, this is your argument if you're the prosecutor, and this didn't happen either. If you're the prosecutor, if you're Lally, you get up and you say, Your Honor, that was a very nice argument by the defense. However, there's one very important part here, and that is the fact that the defense is arguing that they did not consent to this mistrial. That's an error. They did consent to this mistrial. You know why they consented to this mistrial? Because they failed to object. We're in a court of law, and these defense attorneys have showed us that they have no problem objecting. If we look through the transcript of how many objections were made during this trial, there's been probably over 100 objections that were made in this trial of Karen Reed. How come all of a sudden they can't voice their objection to the mistrial that Your Honor declared? They could have gotten up and said, Your Honor, we object to this mistrial right then and there on the spot. The jury is still here. We could have had a conference. We could have had an argument about what their objection is, but they failed to object. And Your Honor, there's no case, absolutely no case, that says that in this situation where the defense attorneys could reasonably anticipate a mistrial, that failing to object does not equal consent. There just simply is no case like that. The only cases, and you can cite all the cases, we've cited them in our previous videos, the only cases that talk about failing to object, all those cases say that failing to object means that you consented to the mistrial. There's only one case, Your Honor, and this is maybe if you want to be real good for the prosecution, then you can say, Your Honor, there is one case specifically where the defense failed to object, and in that case, the court held that was not consent, but that was very, very different than this case. That was where in the middle of trial, without any sort of reasonable attorney would have not anticipated that there's about to be a mistrial. The judge just walked in and declared a mistrial. In that case, the court found that failing to object does not equal consent. That's not what happened here. They deliberated for 25 hours in this case, for days. They already sent out 2 notes saying that they're hung. So if there's any sort of seasoned attorney, for sure, should anticipate that the judge may declare a mistrial now. And if you don't want that mistrial, you have business objecting. And the fact that the defense did not object in this case, that tells us that they consented. If they consented, Your Honor, then there is nothing to talk about. The mistrial was then deemed appropriate because they consented. You don't even have to move on to manifest necessity. Now, in this case, there was manifest necessity because the jury was hung. Now, of course, you have to remember that even under that manifest necessity, there was no reasonable time. There was no full opportunity to be heard, and there was no careful consideration of alternatives. But if you're the prosecution, you could say, Your Honor, even in this situation, still there's manifest necessity because there is the case of Fuentes. Fuentes says specifically in this situation where there was no, there were even in Fuentes, there was an objection. And still, there was no opportunity to be heard, and there was no careful consideration to some of the alternatives. The Fuentes court case opinion held that the mistrial was still appropriate. So even if we were to get beyond the fact that the defense failed to object in this case, and that means consent, even if we were to ignore that part of the law, which I'm not telling you that you should, Your Honor, but even if we were to get past that part, still the Fuentes case says specifically, just like in this case, and the Fuentes case was better because the defense actually objected, and still the court held that the mistrial was still deemed appropriate, and double jeopardy did not attach. That's exactly why in this case double jeopardy should not attach. However, that was my brother Counsel's featuring of what the arguments should have been. However, that was not what the arguments were. The defense argued mostly that we should bring the jury back because it's just not fair, and let's voir dire the jury. That's all we're asking. You're not getting anywhere with that argument. And the fact that the note was ambiguous, you're not going to get anywhere with that argument. They argued a little bit of manifest necessity. He did argue that. He did argue 27B. That 27B does say that the judge is allowed, it's a permissible, may ask for separate verdicts on charges, the different charges that were being charged. The judge is allowed to do that. Again, it's discretionary, but they did argue that. And the prosecution mostly, they loudly concentrated on professional responsibility, that they failed in their the Massachusetts rules of professional responsibility. You're not supposed to have these type of interactions and discussions with jurors, and therefore obviously we should discount everything that came out from those discussions because those discussions were unethical, they were impermissible, and they should have never happened, and therefore obviously we can't give any sort of credibility to those discussions. And he did argue the fact that we all know that since Yannetti asked for a Tui Rodriguez charge, that's just step one in asking for a mistrial, which again, you can argue, well, why is that step one? I mean, yes, we do know, like, it's kind of like we all know the situation here. Like, if we would have asked you, Yannetti or Jackson, do you want a mistrial? Certainly you would have said you want a mistrial. And we all know that's kind of how it works. But technically the defense can argue that's not what the Tui Rodriguez asking for a Tui Rodriguez charge means. It just means that you want the jury to be open-minded and go back and deliberate and find it not guilty. So it doesn't absolutely mean that. He's just loudly just arguing, yeah, well, we kind of all know that that's the first step to asking for a mistrial is asking for a Tui Rodriguez. And then the next step, again, that's not an argument that wins in court. It's just not. You got to focus on the case law, focus on the rules. And if you do that, then you win your case. Now, of course, yeah, they did submit briefing, and the judge is going to take it under advisement. She's going to probably issue an opinion, a nice long opinion, laying out all the law and explaining why she's not granting this motion. But I think on both sides, I wouldn't. And again, the prosecutor Al Malley didn't even argue Fuentes. He didn't argue Fuentes. He didn't argue so much about the failing to object, where there's so much case law. There's so much case law that says that failing to object is consent, and they failed to object here. The only case is one case where it was completely out of nowhere, where the judge declared a mistrial. So these, I think, could have been much stronger arguments, whether you're the defense, whether you're the prosecution. And we were just, maybe, if you're on my side, if you're following this trial, following all the videos that I put out and all the case law that really governs the double jeopardy in Massachusetts, maybe you were a little disappointed about how the oral argument went today, just like me. Well, that is it. And again, I'm going to find it extremely hard to believe that the judge is going to grant this motion. Certainly the way that it was argued, she's not going to grant this motion. If all you're asking for is to bring the jury back, that's not happening. The strong argument would have been that the mistrial was inappropriate, therefore double jeopardy attaches. We've explained this all. Go look at the last videos if you haven't seen a clear understanding of the case law about this case. And that's it. So I doubt this is going anywhere. There's going to be a trial again in January. We'll see what charges Lally decides to bring. Some people are suggesting that he's not going to. How can he bring these charges again when Proctor and Buchanan and all those officers are under internal investigation? And certainly Proctor, who is the lead investigator in this case, how is he going to bring him back on the stand now and make him go through this again? And you think the jury's going to have, he's going to have any more credibility with the jury at that point? We'll see. These are all questions that we will see as the trial comes closer. But in terms of this specific motion, I doubt that it's going to be granted. All right. Well, that is it for now. Thank you all for watching. If you haven't yet, please subscribe, like, and we will see you next time.